Please be seated. The bench is here to resolve the conflict between Prakash versus Fulavati and Dannamma versus Amar. The question is simple yet profound. Does the 2005 amendment to Section 6 of the Hindu Succession Act require the father to be living on the date of the amendment for the daughter to inherit a co-parcenary share? Counsel for the appellant, proceed.
May it please, Your Lordship, the appeal challenges the restrictive interpretation that has deprived daughters of their constitutional right to equality for 15 years. We contend that Section 6 of the Act, as substituted in 2005, recognizes a daughter as a co-parcener by birth. If the right is by birth, it is an unobstructed heritage or aparibandha daya. It exists independently of the father's death or survival on the date the law was amended. To require the father to be alive is to treat the daughter's right as obstructed heritage.
But the phrasing on and from the commencement in the amendment suggests a prospective trigger. How do you reconcile the date of September 9th, 2005 with the right claimed from a birth that occurred decades prior?
My lord, the statute is not retrospective, but it is retroactive. It operates in the future, granting rights from 2005 onwards, but it is biased on an ascendant event, which is the birth of the daughter. Just as a son born in 1970 acquired a right by birth that he could exercise throughout his life, the 2005 amendment simply clarifies that the daughter born in 1970 had the same status all along.
With profound respect to my learned friend, the law cannot be applied to divest rights that have already been vested. Mr. Vineeta Sharma died on 1999. Upon his death, a notional partition occurred under the old Section 6 provision to calculate the shares of the heirs. The son's shares were determined and vested at the moment. To allow a daughter to claim a coparcenary share now is to reopen successions that were finalized years before the legislation even contemplated the amendment.
Counsel, was there an actual partition by metes and or bounds, or merely the statutory fiction of a notional partition upon death?
There was an ordered partition in 2001. My lord, the family has acted upon it. Section 6, Clause 5 specifically protects the partitions effected before December 20, 2004. If your lordships allow this appeal, every settled family estate in this country will be subjected to litigation by daughters and granddaughters, causing massive economic instability in the real estate market. We must uphold the living daughter of a living co-partner rule to maintain legal certainty.
My lord, the oral partition claimed by the respondents is a mere tool for exclusion. The explanation to Section 6 is rigorous. It mandates that a partition must be by a registered deed or a court decree. A notional partition is a legal fiction for the purpose of tax or share calculation for female heirs. Under the old law, it does not disrupt the coparcenary itself. The joint family continues until a final decree is drawn.
We sum up by stating the legislature intended the amendment to be prospective. The word daughter of a co-partner must mean a daughter of a living co-partner. One cannot be the daughter of a co-partner if the co-partner ceases to exist before the act came into force. Prakash versus Pulavati was correct in its construction, and Dannamma was an outlier that should be clarified as such.
My lords, the daughter does not start a new coparcenary. She is a part of the existing one by virtue of her birth. The 2005 amendment is a social legislation designed to correct historical wrongs. Under Article 14, there can be no justification for denying a daughter her birthright simply because her father died on September 8, 2005, while her neighbor's father died on September 10. The right is inherent, absolute, and flows from the birth.
The court has heard the extensive arguments from both sides and the learned amicus curiae. We are of the firm opinion that the interpretation in Prakash v. Fulavati was narrow and failed to appreciate the nature of a Mitakshara coparcenary. The court hereby rules as follows. First, the provisions of substituted Section 6 confer the status of coparcener on the daughter born before or after the amendment in the same manner as a son, with the same rights and liabilities. Second, the right in the coparcenary is by birth. Therefore, it is not necessary that the father co-parcener should be living as of September 9, 2005. The daughter acquires this right at the moment of her birth, and it is an unobstructed heritage. Third, the amendment is retroactive. It applies to all daughters living in 2005, regardless of their date of birth, provided that no registered partition or court decree was finalized before December 20, 2004. Fourth, we clarify that the statutory fiction of notional partition created by the provisor to the original Section 6 did not bring about an actual disruption of the coparcenary. In all pending proceedings, including appeals, daughters must be given a share equal to that of the son. Fifth, a plea of oral partition shall be rejected outrightly unless supported by public documents or registered deeds as per the rigor of the explanation to Section 6, Clause 5. Resultantly, the reference is answered in favor of the daughters. Prakash v. Fulavati is overruled. The appeal of Vineeta Sharma is allowed. Let the pending matters be decided within 6 months.
Good afternoon. Now the question is, why did we choose the case of Vineeta Sharma versus Rakesh Sharma? Because it represents the ultimate victory of constitutional morality over ancient patriarchal norms in Indian property law. There are three pillars of significance we must understand. The end of the living father requirement. For 5 years between the Fulavati judgment in 2015 and this judgment in 2020, daughters were in an illegal limbo. In their father had passed away before 2005, they were told they had no rights to the ancestral home where they were born. The Supreme Court corrected this by identifying coparcenary as an unobstructed heritage by birth. The right is already yours. The death of the father doesn't take away what you already owned by the very fact of your existence. Second, retrospective justice. The court use of the term retroactive is a masterclass in statutory interpretation. A retrospective law would be messy. It would invalidate property sales from 50 years ago. A prospective law would be too slow. It would only help daughters born after 2005. But a retroactive law says, we look at your past to give you rights in the present. The balanced approach ensures equality without causing administrative chaos. Protecting rights from family fraud is a third point. The decision on oral partitions is perhaps the most practical victory for women. In many Indian families, when a daughter asks for her share, she is told, "Oh, we had an oral partition years ago and you weren't part of it." The court has now said, "Show us the registered deed, show us the court decree," or the daughter gets her share. This effectively closes a massive loophole used to disinherit women for generations. In conclusion, Vineeta Sharma isn't just about property. It's about daughters being recognized as a permanent equal member of a family regardless of a marriage or a father's death. As Justice Arun Mishra famously noted during the proceedings, a son is a son until he gets a wife, but a daughter is a daughter for the rest of her life. The Vineeta Sharma judgment hinges on a sophisticated understanding of how laws interact with time. The distinction between prospective, retrospective, and retroactive operation is fundamental to the court's reasoning. The court held that the 2005 amendment does not operate retrospectively, but it does not invalidate transactions that were completed before December 20, 2004. However, it is retroactive because the status of a co-parcener is conferred based on the antecedent event of birth. This ensures that a daughter born in 1980 is treated as a co-parcener in 2005, even though the law wasn't there when she was born. Her right vests at birth, but her remedy to claim the partition of a co-parcener opens with the amendment. The rigor section of Section 6, Oral Partition and Public Policy. One of the most litigated aspects of the Hindu Succession Act is the validity of oral partitions. Under traditional Hindu law, an oral partition was perfectly valid and legally binding. However, the 2005 amendment introduced an explanation to Section 6, which stated that for the purpose of this section, partition means any partition effected by a registered deed or a decree of court. The Vineeta Sharma noted that allowing oral partitions to easily block a daughter's claim would defeat the purpose of amendment. Therefore, they established a high evidentiary bar. Default rule is oral partitions are not recognized. Exception is only in case of exceptional cases where oral partition is supported by public documents like revenue records or mutation entries and is financially evinced in some manner of a court decree which it be considered. Rationale. This protects daughters from sham partitions created by male relatives to avoid sharing ancestral property. Theoretical construct is very different. The court's revival of the Shastric terms Aparbandha Daya and Paribandha Daya was essential to overrule Prakash v. Fulavati. Understanding the heritage logic. Unobstructed heritage. The right is unobstructed because the existence of the father or grandfather does not block the descendant's right. The right is born with the child. Obstructed heritage. The right is obstructed by the existence of only the owner. You can get the right when the obstruction dies. In this case, the owner. By declaring the daughter's rights as unobstructed heritage, the court effectively said that the daughter's rights didn't come from a father upon his death, which would require him to be alive in 2005 or pass it on. Instead, her right was always hers by birth. The law simply removed the gender obstruction that prevented her from seeing the right in 2005. This case has certain social impacts, economic agency, and matrimonial vulnerability. The significance of this case extends far beyond the courtroom. In India, ancestral property is often the primary source of wealth for many families. By excluding daughters, the law historically contributed to their economic dependence on male relatives. First, their fathers and brothers, and then their husbands and sons. Implications for empowerment, financial independence, access to property allows women to have collateral for loans, start business, and even have a fallback in case of marital breakdown. Challenge to dowry. The exclusion from inheritance is often compensated through dowry. By ensuring legal inheritance, the judgment provides a statutory alternative to illegal and exploitative practices of dowry. Residence rights. The judgment reinforces of a daughter's rights to reside in the ancestral home, providing her with housing security. Constitutional synchronization. Articles 14 and 15. The Vineeta Sharma decision is a classic example of reading down or reading up a statute to comply with constitutional mandates. Article 14, equality before the law, and Article 15, prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth, are bedrock of Indian Republic. The court observed that any interpretation of Section 6 that treated a daughter differently from a son regarding birth rights would be unconstitutional and oppressive. The 2005 amendment was a coercive measure, and the judiciary's role was to ensure that the connection was complete and not hampered by restrictive timelines. Procedural clarity for trial courts. Recognizing that the 2015 to 2020 period of uncertainty that led to thousands of stayed or dismissed suits, the Supreme Court issued specific directions to the lower judiciary. Mandatory inclusion. All pending partition suits must now include daughters as equal co-parceners if they were alive in 2005. Reallotment of shares. Even if a preliminary decree had been passed determining who gets the what share, but the final decree physically dividing the land had not, the courts must recalculate the shares to include the daughters. Time-bound resolution. The court requested high courts and subordinate courts to dispose of these matters within 6 months. Conclusion. A legacy of equality. The judgment of Vineeta Sharma versus Rakesh Sharma in the final word of a century-old struggle for gender parity in Hindu property law, by rooting the daughter's rights in the concept of birthright, the same foundation that has served sons for millennia. The Supreme Court has ensured that the status of a woman in her natal family is no longer a gift of a male relatives or a contingency of a family's survival. The court's decision to adopt a retroactive application and a strict evidentiary standard for oral partitions demonstrates a deep understanding of the practical barriers women face in claiming their rights. The judgment is not merely a legal victory, it is a cultural and social milestone that redefines the Hindu undivided family as inclusive institutions where the daughters are equal stakeholders from birth to death. As legal professionals and researchers, we view this case as the definitive authority that harmonizes Shastric tradition and has a vision of the Indian Constitution and with a progressive vision. Gender equality and Coparcenary. Vineeta Sharma case 2020.